welcome you to the Washington Legal Foundation's web seminar series. My name is Glenn Lamy. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 38th year of free enterprise, public interest law, and policy advocacy and education. We have sort of three things that we do here. We started out as a litigating group 38 years ago. That is still our backbone in terms of advancing our interests and goals and our mission through amicus and original litigation in state and federal courts at all levels. We're very active in the Supreme Court primarily. We also have our Legal Studies Division, which is sort of our think tank side. We feature the expertise of authors that write our publications. Our two speakers today have each written a publication for us within the last year or so, and all of those are available on our website. And our communications side features programs such as this one, media briefings, a blog, the WLF Legal Pulse, as well as op-eds every now and then. If you are joining us online, I encourage you to spend a little bit of time on the website after the program is all over with. Thanks to advances in technology, the ingenuity of entrepreneurs, and the need for businesses to reduce costs to maximize efficiency, America has undergone a workplace sea change over the last decade or so. That has in turn altered the traditional employer-employee model. These changes have not set well with some in the private and public sectors, and so in the last several years we've witnessed a concurrent revolution in how employment rules and those who enforce those rules at regulatory agencies and courts view the concepts of employer and employee. As an institution that fights for such basic concepts as a consistent, transparent rule of law, procedural due process protections, and lawmaking driven by the democratic process, WLF has become very concerned with how these changes have unfolded. Advisory devices such as administrators' interpretations have been used to alter the concept of independent contractor. The way that regulatory agencies consider who is an employer has been upended by federal enforcement actions and agency amicus briefs. Class action lawsuits, which put rulemaking in the hands of unelected judges and juries, have also played a major role. Discussion of these issues most often arise in the context of labor versus management, And while unions may be the consensus beneficiary of this revolutionary change, the implications for employer liability, regulatory exposure, and the ability to just plan and run a business should not be overlooked. To explain the changes afoot to the concepts of employer and employee, and to assess their immediate and long-term implications, we're pleased to be joined today by two leading employment law practitioners whose work lies at the intersection of law, public policy, and business planning. Leading off today will be Michael Lotito, who's a shareholder in the firm Little or Mendelson, practicing in its San Francisco office. He is also the co-chair of the firm's Workplace Policy Institute, which provides advocacy services for clients, associations, and policy leaders on all workplace concerns. In addition, he practices all aspects of traditional labor relations, including matters arising under the National Labor Relations Act. He has testified before the U.S. Senate, U.S. House of Representatives, as well as the Equal Employment Opportunity Commission. Following him will be Gregory Jacob, who is a partner in the Washington, D.C. office of O'Melveny Myers, and a member of the firm's financial services and labor and employment practices. His practice focuses on employee benefits litigation and counseling, and he represents a variety of financial services companies, including banks, healthcare payers, and insurers. Mr. Jacob served as Solicitor of Labor, the third-ranking official in the Department of Labor during the presidency of George W. Bush. We're going to be taking questions by email. If you are interested in emailing us, the email address is interactive@wlf.org. After their presentations, we will be doing a Q&A session, and I'd be happy to forward any questions that you have to them. Mike, if you can get us started.
Thanks very much, Glenn, and hello, everybody. Nice to be with you to talk about who is an employer and who is an employee. You would think that after 40 years of doing this, I kind of know the answer to that, but I don't know the answer anymore, and I guess that's why we're here. The architect behind the discussions that we're going to have with you for the next little while, I think, is a gentleman named David Weil, who's currently the administrator of the Wage and Hour Division for the Department of Labor. And I think it was in 2010, 2011, he had been hired by the department, wrote a paper that talked about some of their enforcement issues, but also discussed the concept of the fissured workplace, which I had not heard before. The idea, as he focused it in on whether it's franchising or staffing agencies or independent contractors or wasn't so much the gig economy then, but the whole idea of the contingent workplace, is that there were employers that were quote unquote hiding behind, either intentionally or unintentionally, other kinds of corporate structures that were insulating those employers from the actual responsibility and obligations that they had towards the people that I'll refer to as the ultimate employee. And he made a variety of suggestions as to what to do about that. Right before his confirmation in 2014, he actually wrote a book published by Amazon called The Fissured Workplace. I suggest you get a hold of it. I promote it everywhere. David has yet to send me any royalty checks, but it's okay, David, because I carry it with me everywhere, and I no longer need Tylenol PM. I just open it up at night, and I'm much better for it in the morning. But it's interesting because, for example, there's an entire chapter that just deals with franchising. And if you want to understand, I think, the overall philosophical basis behind what it is that both Greg and I are discussing with you today, I think it begins with David Weil. Now, right at the same time that Administrator Weil was writing, the McDonald's cases began. And the very first unfair labor practice charge that had been filed against McDonald's goes all the way back to November 28 of 2012. So we're coming up on about 3 years. The charge gets filed before a regional office. It alleges joint employment. Should have been a no-brainer based upon 30, 40 years of precedent that the franchisor doesn't have any joint employment responsibility, got kicked up to the general counsel's office of the labor board, Richard Griffin's domain, division of advice, which, as the name implies, gives guidance to the regional offices as to whether or not they should, based upon investigation, issue a complaint or not. Did write an advice memorandum, which we've been asking for, but which has been kept under wraps because there's ongoing litigation, which is nonetheless disappointing from the most transparent administration in history. And we don't know exactly what the general counsel's theory is, but after 2 years of investigation, the joint employment complaints began to get filed. And there's now a ton of them. And there are many franchisees of McDonald's that have been hit with these complaints. There's been at least 7 position statements that the company has filed. I get these stats based upon a filing that McDonald's had with the division, with the administrative law judge in the case from last Friday. In that filing, they say that they have produced over 100,000 pages of documents, and that internally, not accounting for their outside legal fees, they've spent over $1 million in trying to comply. This filing was asking that there be no more continuances given in the case, which is now supposed to begin again on January 11 in New York, then go to Chicago, then Los Angeles. And in this filing, the McDonald's counsel projected that by the time the appeals are said and done, that it will take 10 years, not clear, 10 years from 2012 or 10 years from 2016 for the matter to be resolved, but what's a few years among friends. This will probably go down in history, absent some kind of settlement that nobody sees, as the most contentious and longest NLRB action, certainly since Beverly Enterprises or J.P. Stevens, if you're old like me and can remember that far back. What was surprising, as I said, about these complaints is that there had been settled authority, Love Barbecue and some other cases that made it very clear that the franchisor and the franchisee were not joint employers. And indeed, there's another division of advice memorandum which does not get very much publicity called Freshie, where Mr. Carney, great lawyer, career person at the NLRB, calls it like he sees it, found that there was no joint employment relationship between Freshies and nutritionality because there was no control that had been exercised. So that kind of gave some comfort, at least to the franchising industry, that maybe not always nearly as bleak, and maybe McDonald's is just sui generis, but there's a lot of concern. What's the difference between a Freshie situation and a McDonald's situation? And it became further confused because we had the August 27, 28 decision in Browning-Ferris by the Labor Board. So distinguish a division of advice memorandum, which is just the opinion from the general counsel, the prosecutor, from the BFI decision from the Labor Board, which is an actual decision from the board, and sets forth what the board's position is on joint employer going forward, which the general counsel, as well as the regions, are obligated to follow. And so while Browning-Ferris, through a torturous process under the statute, because it's a representation case, is now on appeal, clearly this is the law that's going to be applied in all future cases, and actually Browning-Ferris has a retroactive effect. This is not a franchise case. It's a staffing case. And the board, again, was confronted with 30, 40 years of precedent that had held that unless one employer exercises direct and immediate control over the employees of the other employer, there's no joint employment relationship. And so the majority of the board, a 3-2 decision before Harry Johnson left, changed the law. And they said that we have an obligation to interpret the statute based upon changed circumstances. And part of those changed circumstances is that we now have this contingent workplace, echoing really what David Weil has to say, although they didn't cite directly to his book. And we're going to take a new look at this. And we're no longer going to have a direct an immediate test, but instead we're going to have a two-part test. Part number one is, since we only have jurisdiction over employers, we first have to determine whether or not this secondary entity, if I can refer to it that way, is or is not an employer. They said we're going to do that based upon the restatement of agency. And under the restatement of agency, it says that there's a joint employment relationship if there's actual control. Now, it didn't define whether or not it's direct control or indirect control, it just said control, or, and this is, I think, the key, right to control. Direct, indirect is that control has been exercised. Right to control is you do not have to demonstrate that any control, direct or indirect, was exercised, but rather it's been reserved in some fashion, which at least according to one of the board members who's spoken after BFI at a conference, quoted in the media, said something to the effect that this is essentially a contractual relationship. And once you make the determination under the restatement of agency that you've got the joint employment status with right to control or control, which is different than the general counsel's amicus brief in the case, because he had argued for direct or indirect, and people have said, well, they didn't go as far as the general counsel wanted. I would argue against that position, and I would say that the board went beyond what the general counsel wanted. There's a footnote 68 that discusses this in mind-numbing detail. True definition, if you want to get weedy, go to footnote number 68 and take a look at this. But I think that this concept of right to control, potential control is the way the board is talking about it. Sometimes it comes out as ultimate control, is much broader than what the general counsel was arguing. And I think that it is virtually unlimited in its application. And at the risk of completely boring you, I'm actually going to read something from the decision. Not going to take long. Hang in there with me. You're being a good audience so far. This is on page 14 of BFI, where the user firm owns and controls the premises, dictates the essential nature of the job, and imposes the broad operational contours of the work, and the supplier firm, pursuant to the user's guidance, makes specific personnel decisions and administers job performances on a day-to-day basis. The employee's working conditions are a byproduct of two layers of control. So in the case involving the staffing company, was a recycling facility. The supplier employees, or the temp agency, naturally the work was being done on the premises of the user. It was their reprocessing or recycling facility. They provided broad operational guidance. We're going to have 3 shifts. The first one starts at 7. You're going to have to work on the line. You got to, wear protective devices. You got to make sure that it's safe. We want you to pass a drug test before you come in here because this is heavy equipment. We don't want anybody to get hurt. We expect you to recycle, and this is the way it's going to be done. Those are broad operational contours of the work. And the supplier firm, the temp agency, they had person on site that did the day-to-day operational control with respect to their own employees and made determinations about them. The labor board says, boom, we got 2 layers of control. Now, in a staffing situation, I defy anyone to try to figure out how you don't meet that test. I mean, you hire a janitorial company and you say, I think you're the best janitorial company in the world. I trust you enormously. I don't want you to clean my building, however. I want you to clean somebody else's. Well, why in the world would anybody do anything like that? You hire a food service company in order to run the cafeteria for your employees at your complex in Silicon Valley because they have campuses there. Well, I don't want you to do the food services in my buildings. Make this stuff somebody else, and then maybe we'll get a trucking company. Let's not even try to figure out who the real employer is of them, and they'll ship it in even though it's liable to be cold. Well, come on, nobody's going to do that. The more difficult question is, how does this apply in the franchise setting? In the McDonald's case, McDonald's owns the land, and the franchisee is leased back. That's an unusual situation. Most franchise situations are not like that. But you can see that if you substitute the term supplier-user for franchisor-franchisee, where this is going. So, why is this happening? Glenn said we like to talk about policy, and I think it's important to understand in broader context here. Union membership is 6.5%. I started out a long time ago, and it was 25%. Highest amount was 35% of the workforce. If you heard the debate the other night, maybe it wasn't every other word, it was every third word or phrase, talked about income inequality. If you paid attention to the White House summit last week, where Mary Kay Hendry, the head of the SEIU, and among others, including Secretary Perez and the President were there, talking about workplace voice, making in some instances very direct reference to the fact that one of the reasons why we have income inequality in the United States is because organized labor now only represents 6.5%, not like the good old days when my father was a UAW member working at Todd Shipyard in New York. A different day, different time. We didn't have a global economy because we had just blown up the world. And if you wanted to buy anything, you had to buy it from us because nobody else could make anything because they were trying to survive. And my father, with an 8th grade education, was able to save up enough money to send his kid to a fancy school, Villanova, so he could come and make speeches like this. We need more of those good old days. So if we increase union market penetration, they will negotiate favorable collective bargaining agreements. We no longer will have to worry about this $9, $10 an hour stuff. We will diminish the amount of wealth that the 1%, or the less than 1% has, and will be much happier as a single society. That's the argument. There is some legitimacy to that argument, because as Holden Caulfield said, nothing is all true. But the problem with this, and then I'll stop, is that the board, in my view, most properly says in its Browning-Ferris decision that we have an obligation to take a look at a 1935 statute, 80 years old. Last really significant amendment was 47. With Taft-Hartley, to take a look at this statute in light of changed economic and practical circumstances with respect to the workplace. I totally, completely get that. And I think that that is part of their charter. And they say that what we do is we look at the findings and policies section of the statute that says it is the policy of the United States to encourage the practice and procedure of collective bargaining. That's exactly what it says. It has never been designed to be a neutral law. It is a law that's been designed to put people into unions and once they're there to keep them there. But there's a phrase before encourage the practice and procedure of collective bargaining. It says it's hereby declared to be the policy of the United States to eliminate certain causes of substantial obstructions to the free flow of commerce and to mitigate those obstructions when they've occurred by encouraging the practice and procedure of collective bargaining. It's in there, just like I said. You can look it up. Trust me, I'm a lawyer. And what the board ignores, totally, completely, absolutely, never, ever makes reference, is that we have a dual responsibility, encourage the practice and procedure of collective bargaining, but not go so far that we create obstructions to the free flow of commerce. And what are the obstructions that the board is creating? The McDonald's franchisees who want to settle these ULPs cannot. The labor board will not let them unless there's an agreement on joint employment, which they can't agree to. How can a franchisee say McDonald's is a joint employer? They have no power to do that. Same way the other way. So instead of having a nominal settlement with virtually no legal fees, they're looking at hundreds of thousands of dollars of legal fees, years of uncertainty, 10 years of litigation. That's an obstruction to the free flow of commerce. Business needs certainty to be able to structure relationships. The majority has said, why is everybody getting so excited? Now listen to dissent. We're going to decide this on a case-by-case basis. Case-by-case basis is code for we can't tell you how to establish business relationships are going to comply with the law because we can't clearly articulate our standard. Give us 5 years, give us 10 years, give us 15 years of litigating cases against you and others like you because we have unlimited resources called the United States government while you don't. And 10 or 15 years from now, we'll know what the new standard is, and you will have certainty with respect to your business relationships, all in the name of encouraging the practice and procedure of collective bargaining. Yeah, you're doing that for sure, because this is all about increasing union market share in order to lower income inequality, assuming that it would even do that through multi-employer bargaining, through neutrality and card checks. But you're doing it at an enormous expense because we no longer have business certainty. Because if you don't know who the employer is, we had a big problem.
Thank you, Mike. All right.
Well, thank you, Glenn, and the Washington Legal Foundation for inviting me here to talk on this topic. As Glenn noted, I served as Solicitor of the Labor Department from 2007 until 2009. And now that I've been on the outside looking in for the period since then, there hasn't been a day that's passed when I don't read the headlines coming out of the Labor Department and think, that is terrible for America, but great for my law practice. All those 10 years of uncertainty that Mike talked about, it's only good for the lawyers. It's certainly not good for the businesses. And whereas with respect to the joint employer doctrine, we really have seen the NLRB leading the charge and trying to make those changes, we've seen a multi-prong assault on the topic of independent contractors and redefining where the line between an independent contractor and independent business and employee starts. So I'm going to give you just a little sense of where things have been over the last few years and where they are today on this subject. In 2010, I was invited by the National Association of Attorneys General, wonderful organization that abbreviates to NAG, also sometimes called the National Association of Aspiring Governors. But they, of all the topics that they could think of that they wanted to put a panel together on independent contractor issues. They wanted 3 people to come in and talk to them about independent contractor issues because of the issues that they were experiencing in their states and the calls that they were getting for new enforcement initiatives there. In 2011, the next year, the Labor Department entered into a memorandum of understanding with the IRS so that the Labor Department and the IRS could more effectively police their enforcing and give information back and forth that would help them both identify independent contractor issues. Since then, 26 states have entered into memoranda of understanding with the Department of Labor to, again, share information back and forth. Let's identify targets and so that we can be more effective at pushing the new lines that we want to draw. In 2014, David Weil was confirmed to be the head of the Wage and Hour Division. In that year, the Labor Department collected $79 million on independent contractor issues with a focus in the areas of janitorial services, temporary help, food services, daycare, hospitality, and the garment industry. That's their focus. If you're not in one of those, don't rest easy. And then in July of this year, David Weil issued an administrator's interpretation in which they said, well, we've had all these years of decisions under the Fair Labor Standards Act that have dealt with the question, who is an independent contractor, who is an employee, and just as the NLRB did with an actual decision, with this administrator's interpretation, just a guidance document issued under the signature of the director, they attempted to redefine the way that the law should be applied, particularly away from the common law control test or emphasis on control and more towards questions of economic dependence. And I'll get to that in a second. And then in September of 2015, just last month, the Labor Department issued $10 million in grants to the states to help them in their enforcement efforts with respect to their unemployment compensation funds. So we see a tremendous amount of coordination and a tremendous amount of energy among various federal and state agencies to enforce these new lines that they're attempting to draw on what it means to be an independent contractor, what it means to be an employee. Now, this has become such a hot topic, we've even seen this come up in the presidential race, where questions about Uber have been asked, and the new economy, and different candidates have been asked to weigh in. I'm greatly hoping that this doesn't actually become a debate question for 2016 when the actual candidates have been selected, because I have $1,000 that I owe a client if, in fact, one of the debate questions is. So where do things stand here? What is the reason that this is such a big issue? Virtually every large or medium-sized business uses independent contractors in some fashion. In part, the world has to work that way. At O'Melveny Myers, we, of course, are an employer. Occasionally, we need a plumber. Occasionally, we need somebody to reconstruct part of the facility. We're lawyers. We don't plumb, and we don't construct. So we hire an independent contractor to come in and do that kind of work. Those are the easy cases where even the Labor Department agrees, all right, those are fairly independent contractors. Those are independent businesses. But there are a whole range of situations beyond that. We have an IT department, but sometimes we need somebody to do a specialized IT thing on a particular project. Or maybe we need somebody to come in for a while to train our people, but they're not somebody that we want to have an employer as an employee for a long period of time. So for reasons of flexibility, reasons of controlling headcount, which becomes particularly important with things like the Affordable Care Act, for all these reasons, this is a real issue for many of my clients where they have independent contractors. For some of them, it's their actual business model to use independent contractors. For others, it's because they have people who they use in a variety of circumstances. But the stakes are very, very high here where you decide to classify somebody as an independent contractor. You can run into, I mentioned all these different agencies that are involved. So what are the problems you can run into? Well, with your independent contractor, if that's the way you're treating them, you're not paying attention to the minimum wage laws. You're likely paying them at least minimum wage if you work out all the hours, although not necessarily. But overtime, are you paying attention to the number of hours that they worked and paying them overtime? No, you're not. And that's a problem at both the state and the federal levels. Then you've got problems under ERISA. If you've got them classified as an independent contractor, you haven't put them into your employee benefit plans. And they may have rights under those employee benefit plans if you've misclassified them and you haven't put the right language into your plan to make sure that they are excluded. With the IRS, you're not doing their payroll deduction, so the IRS wants a chunk. And the reason that the states are so interested is they've got their worker compensation and unemployment insurance funds, and you're supposed to be contributing to that on behalf of your employees. And so it's a win-win for the AGs, particularly in the blue states, where the unions love it if they get moved from independent contractor to employee status. Oh, all of a sudden we can unionize those people. You can't unionize the independent contractors, but the employees you can. So you've got that back that they're scratching, but then they're also helping fill the state coffers, which have been depleted in recent years by collecting in all of those taxes. So they're tremendous, and all of these are areas where you as an employer have potential liability when you employ these folks. But then you've got this maddening problem. All right, so I've got this potential mountain of liability sitting on my head. Let's take a look at the law and figure out who is an independent contractor and who is an employee, and I'm just going to make sure that I get it right down the line. Well, it's not that simple at all. All these different laws, all these different divisions, all these different departments, they all have different tests for what counts as an independent contractor. The IRS has a 20-factor test. Under ERISA at the Labor Department, you employ the old common law test, the federal common law version of the common law test. Under the Fair Labor Standards Act, you employ the economic realities test, which is a 6-factor test. And then all these states have different statutes and different regulations. And even where they have the same language in those regulations, those states may interpret them differently. So it's very difficult to figure out what the law actually says in this area. The GAO in 2006 studied this area and said that the tests that are available are, quote, complex, subjective, and differ from law to law. And that subjective part is another key component. Even when you're looking at just one of those laws, the factors that you take a look at, the 20 factors under the IRS test, everyone will say under all the tests, whether you're under the IRS 20-factor test or you're under the FLSA 6-factor economic reality test, no one factor is determinative. So you've got the easy cases, the plumbers and the carpenters, who you're just bringing in for temporary projects. And then you've got easy cases on the other end. If I tried to take all of my associates and counsel at O'Melveny Myers and make them independent contractors, that wouldn't work. They're employees. They're doing the main business of the firm. They're there every day. We control what they do. So you've got those easy cases, but you have a huge number of people who subsist in the gray area in between, where even under any one of these individual laws, it's very difficult to figure out where they fit. So how have they been trying to push the lines here? So it's not going to be worthwhile for me to talk about all these different laws. I can't possibly do it. So let me first just lay out what the general framework under all of these is and give you some sense of what these government agencies are trying to do in terms of moving the line. And then I'll finish up just by talking about some of the more interesting cases that have popped up in the last year or so. So under the old common law test, the key factor that you were supposed to look at, and this is still true under many of these different tests that are out there, is control. How much control is the employer exerting over the worker? And you use that to figure out, are they an employee, there's lots of control, or are they an independent contractor? The problem with that test is, again, lots of gray areas. You can think, probably there's some general counsels who are on watching this webinar right now. Think about how much discretion you have in the way that you apply your job every day. Yet you're an employee of your company, right? So you can make an argument in many circumstances that you have a lot of control of somebody, or that in fact they have very little control over the way that they do their work every day. And there's just lots of room for argument there across those circumstances. Then you have the question of economic dependence. And this is where the Labor Department really wants to push things to focus on. In that administrator's interpretation that I mentioned, one of the key things they said is, we want to get away from this idea of control, which is susceptible to employers structuring things where you have the illusion of control, but really the employer is controlling every aspect of their job or setting very clear parameters within which they must work. And we want to really get into this question of economic dependence. Is the worker dependent upon that particular employer? And the factors that you're looking at there are, well, are they an independent business? The plumber, right? He's got an independent business. He's going around and seeing 10 different jobs a day for different people. He may have his own employees. He's separately incorporated. Well, you've got a range of gray areas there as well as to whether they are that. You look at the permanency of the relationship. The plumber just came in once, but if I had somebody who was on staff at the firm every day of the year and all they did was plumbing for us, we certainly don't have enough plumbing facilities to make that work, but the permanence of the relationship is one of the things that courts look at there. And then another aspect of being an independent business is the opportunity for profit or loss. Do they control their ability to make more money or not? If you're an independent business, you would think that, yeah, you can set conditions, the number of hours that you work, the number of jobs that you do, the way that you structure your business, the risks that you take. Do you bear those risks? Those are all aspects, and that's what the Labor Department wants to focus almost exclusively on, because they're convinced that under the FLSA, quote, most workers are employees, close quote. So that's their bottom line conclusion. Presumptively, you're an employee, and it's going to be a very high burden under their presumed test for this to figure out whether or not you are, in fact, an independent contractor. And then another related question they ask is the work that this person is doing integral to the business model? Is what this person is doing actually the work of the employer? So it's very much more difficult for me at O'Melveny Myers to take an associate who is doing the legal work of the firm and to cast them as an independent contractor, because that's just what we do. But you can come up with circumstances where even the Labor Department would acknowledge it may be sort of what you do, and yet you can be an independent contractor. So for example, they say if you're a construction company, your carpenters are generally going to be the people who are doing what you do. So they've got to be employees. But the department acknowledges maybe you occasionally bring in a really skilled craftsman to do particular projects, really particularly nice library shelves that just come up from time to time. And that person actually does that for 7 or 8 different construction companies in the area. Even they would acknowledge, all right, well, that's an independent contractor. It's sort of what you do. You do construction, but that person is clearly an independent business. They're doing different things. They're not regularly engaged for you. Or maybe they are regularly engaged, but it's on a sporadic basis, and they're clearly not economically dependent upon you. And that also goes to the question, do they have special skills? This is one of the questions that they ask on this, because that person does have special skills. They're specialized, and you just bring them in for those specialized things, as compared to your carpenters who have a specialization of sorts. I couldn't do what they do on any given day, but they are simply doing the same basic skill set that your normal work requires. So this is the suite of factors and the different options that are out there. And then, of course, there's the gateway question. Do you actually have a contract with them? If you want to have your people classified as independent contractors, a good idea, not necessarily absolutely legally required to have it set out in writing, but it's foolhardy not to have it set out in writing so that there's at least a clear mutual written understanding between you. That's not going to get you out of jail free. Under all these tests, you're going to have a contract that says you're an independent contractor, we agree you're an independent contractor, and yet you may well be held liable for things. So, taking into account that those are the tests, let me talk about some of the actual cases that have come up in the last couple of years and the way that those have been pushing the line. One of the key cases, and this is the one that's come up in the presidential debates, is Uber. I used Uber a couple of months ago, and I just thought I would raise the question with the driver, what's it like? The taxi cab companies aren't very happy with you guys, et cetera. And he said, you know what? I've been an employee. I'm not an employee. I'm an independent contractor. That's just what I am. I know what it looks like to be an employee. I get to set my own hours. I get to pick my jobs. I get to pick what kind of gas I put in my vehicle, which affects the longevity of the vehicle on the one hand. On the other hand, how much I'm paying for that gas affects my profit margin day to day. I can't do any of those things as an employee, but as an independent contractor, I am. Well, there have been some authorities out there. The state of California, in the case of Uber v. Berwick, Berwick, just in June of this year, took a look at an Uber driver. This is somebody who had their own separately incorporated entity. That's where Uber was sending the payments to this corporation that this person had. But they said, no, this is the job that Uber does, is they supply drivers. This is the driver. This was integral to your business. True, the person could work whatever hours they wanted to, but you had to approve each individual driver. True, that person could have hired another driver who was subservient then to them to also do the work, but Uber would have had to approve them as well. And Uber tries to do things like discourage them from taking tips because that's inconsistent with their business model, not absolutely prohibited, but discouraged. So they saw these elements of control, but they certainly saw economic dependence. This person wasn't doing the driving for others at the same time. And frankly, even if they had been, I don't think it would have changed the way that California came out on that particular case. So being able to set their own schedule, their own hours at will, hire those people, those things were not enough in the Uber case. Also in June of 2015, the Scarlett's Cabaret case. This dealt with exotic dancers that a number of facilities had brought in as independent contractors. They said, hey, you've got your own opportunity for profit or loss. You control your show within reason, and your tips are going to be what you make, and you're an independent contractor as a result. The court never got to a decision there. They settled for $6 million that they dispensed to more than 4,000 exotic dancers in the case. But the key problems that they had was these places required that a certain percentage of the money that these people got then go to the security guard and the bartender. They said you have to be here at least certain hours a week. They set certain aspects of the schedule. Unclear how that would have absolutely come out in court at the end of the day, but in all likelihood, they would have been deemed to be employees under those circumstances, and so probably a wise settlement. $2.5 million the Labor Department got in July of 2015 from National Consolidated Couriers. This is a courier company. They hired people to go out and just take various courier missions. Again, they controlled their own schedule. They were allowed to do what they want, but they had that National Consolidated Couriers badge. That was one of the things that the court pointed to. This wasn't a consent judgment. This was the court ordered this. And they had that badge, and they're holding themselves out as being National Consolidated Courier, the representation of the company. Now, that shouldn't be a determinative factor if you look at it under the old common law test, but more and more courts have pointed to that. That's one of the things that got FedEx in trouble in the FedEx ground cases. All those folks were required to wear the FedEx uniform, so they didn't look like to somebody. If somebody was making a delivery to my house, they did not look like an independent contractor, someone independent of FedEx. They looked like FedEx. And even though those people were able to, again, hire their own drivers, have additional routes, control their own schedule and routing, there were a lot of elements of control there that it was determined to, that they were determined to be employees by now both the Seventh Circuit and Ninth Circuit. The Seventh Circuit derivative just of Kansas law in particular. Now, FedEx has had a checkered record. It's varied from state to state, and again, you've got to take a look at those laws, but it's been small comfort to FedEx that they've won in certain states because they've, I believe it was like a $228 million settlement that they entered into with respect to their California cases alone. There is some hope out there. I'll just close by mentioning gate guard services, where the Fifth Circuit imposed equal access to justice fees on the Labor Department. This case is great. It started as I think so many Labor Department investigations do with drinking. This Labor Department investigator was sitting at a bar with one of his buddies, and his buddy said, oh man, I work for these gate guards people. I think that they didn't pay me right. Could you take a look at my pay stub? And so they get into the conversation. The person doesn't find any miscalculation in the way they were paid, but concludes, actually, I think you're probably not an independent contractor. And the way gate guards worked, they would put these gate guards, they sort of hooked up businesses that needed guards with guards. They would supply them to them. And the folks were independent contractors. They could pick the jobs or not. They frequently slept at the sites. They would live at the sites that they went out to. They would pick the job and whether or not they wanted to do it. And gate guards, however, if they were out at some remote location, had people who were employees who would go out and supply them with food, et cetera. At the end of the day, everybody agreed these folks actually were independent contractors, at least within the Fifth Circuit, rather than employees. But the Labor Department, this guy who had had no training on doing independent contractor classification issues, sent a dunning letter to Gate Guard Services, said, I think that you got guys misclassified. I want to set up an appointment for next week. So they set up that appointment. The guy then shows up a week early, starts inquiring of the various employees that he finds on the site to get details about things, talks to 3 employees, and then issues a $6 million wage hour violation notice to gate guards. that, among other things, counted every single hour that those people had been at the facility, including the ones that they were sleeping and eating on the premises, all as work. Labor Department ultimately confessed, yeah, this was a huge mistake. This guy violated all of our protocols. The Labor Department didn't acknowledge that they weren't, in fact, independent contractors, but acknowledged he didn't have authority to do that. Certainly that $4 million that was attributable to sleeping and eating shouldn't have ever been part of the equation. The Fifth Circuit said this was bad faith prosecution, and they're going to have to pay. We don't know exactly how much, what the ultimate fees are going to be there, but it's going to be a nice chunk of change because of the way the Labor Department investigated that. So there is a backstop in the courts at the end of the day here, but it's a scary world that you're living in where you see how aggressive an agency is willing to be. They don't all start at the drinking table. But you need to beware of the line that they're pushing here and the way that they're trying to move away from the control test that was a little easier for folks to understand, if only because there were years and years and years of developed cases that you could look at. And even though the test itself is somewhat vague, you had lots of different factual circumstances that you could point to. And you could say, well, in this case, which is very analogous to ours. But what the problem is these agencies are pushing more towards an economic dependence analysis as integral to your business and trying to elevate those to be at the top of the pile. Well, we just don't have the cases. And so again, we're plunged into the 10 years, 20 years. I mean, this has taken 100 years in some states to build up the common law test and to have enough that people could really understand what it is. So again, that uncertainty, terrible for America, great for my law practice, and good luck to all of you watching this webinar.
Thank you, gentlemen. Mike, I wanted to ask you to address, are there next steps in the Browning-Ferris case, and sort of what's next in light of the Browning-Ferris case with the McDonald's case before the NLRB?
Well, the Browning-Ferris is a representation case, so you can't directly appeal that decision. But the union did win the election. A request for bargaining has been made. That request has been rebuffed, and the board has filed unfair labor practices against the company, actually the successor, I think it's Republic now, for refusing to bargain, and that will ultimately result in a summary judgment determination before the labor board, which will then lead to appeals into the courts. So we'll see what happens with that case. I should have mentioned that there's another case, CNN, which is also on appeal, and I think we'll probably get a decision in CNN in 2016, and there. The board said in the case, which had been languishing for 10 years now that I'm thinking about it, that there was a joint employment relationship, but under their old standard. And the dissent said, you're not really using the old standard. So it's not exactly on point, but it'll be interesting to see what the circuit court, I think it's the Second Circuit, but I could be wrong, has to say about that. So that CNN case is very important. With the McDonald's situation, my understanding is that there will be an oral argument at the end of October on the discovery dispute. The discovery dispute is enormous. The general counsel was filing briefs, and there was one that was publicized the other day setting forth the fact that he's got I think 118 different categories of information that he's seeking from, I forget how many custodians, including HRP. I mean, it goes on and on and on and on and on. So I don't know what's going to happen in McDonald's, but there are other unfair labor practices against other brands in the franchise context, and clearly we're going to get additional ULPs, whether it's in staffing or other types of situations, that will probably wind up getting litigated before the board, before the McDonald's case actually ever gets litigated. And then, I don't know how much time, I'll stop briefly, but you know, the 2016 elections matter in this whole thing, because elections do matter. And you know, if you wind up in 2017 with a Republican in the White House, if you're RRR, there'll be a slowdown in this beginning in 18 or 19. But if you go DDD, watch what you wish for, because there ain't going to be any slowdown, and there's about 67 variations in between all of that, since I have no life, I actually think about.
So if there's an eventual appeal in the Browning-Ferris case, would that be to the D.C. Circuit directly, or?
They can certainly go to the D.C. Circuit because that's where the board is. A lot of people have really thought seriously about whether or not you want to be in the D.C. Circuit because of the changes that have been made there. And I'm not really sure where the current employer does business, because they could go to whatever circuit, because the operation is in Arizona. Well, for sure, you don't want to go to the Ninth Circus on this, so you got to go someplace else. So we'll see where they wind up going. But ultimately, we'll have splits in the circuits all over the place on this issue.
With the administrator's interpretation, Greg, a lot of times courts have looked upon those sorts of things as sort of direction as to how they should interpret state laws and other laws that are similar to what the federal government has. Do you have the administrator's interpretation on independent contractors having any influence in either federal or state courts going forward in any of these class actions?
So the administrator's interpretation on its face is just an interpretation of the Fair Labor Standards Act itself. And it itself, it's not entitled to Chevron deference. It didn't go through rulemaking, nor is it an interpretation that could be subject to our deference, as the courts have sometimes called it, where if you're interpreting your own ambiguous regulation, you might get some additional deference here. It really is only entitled to power to persuade deference, because it's a direct interpretation of the statute and what it means to be suffered or permit to work under the FLSA. So within that universe, the interpretation itself is very clearly geared towards that unique FLSA test, which it says right at the beginning, hey, there was a common law test that used to exist. Congress expressly rejected the common law test in enacting the FLSA. Instead, we have this economic realities test with the D6 factors and the suffer permit to work standard. And so our interpretation is going to be geared towards that. I think that we can use that to limit the department's influence on the courts, because anybody who's applying a common law test in a state or applying a different statute, you have a very clear dividing line. But the administrator's interpretation also gives some very specific examples with some very specific reasoning as you go through it as to why they think certain relationships are employees or independent contractors. And I think inevitably for a judge or a state ALJ who isn't that familiar with these things or is sort of inclined to go in that direction, they'll inevitably reach out and grasp a hold of that. So it'll move the ball a little bit, but we who need to defend against it have very good tools to do that as well.
Mike, a question from one of our viewers. With the NLRB's joint employer decision, what kind of influence is that going to have or impact is that going to have in the enforcement of the laws by other agencies such as the EEOC with discrimination claims or OSHA with workplace safety claims? Are there going to be different layers of employers now that are going to have to worry about exposure to that sort of regulatory risk?
Well, that's a great question. OSHA, let's take that one first. About 3 days, I think it was, before Browning-Ferris came out, there was a leaked OSHA memorandum that got to our attention, ours through the International Franchise Association, and it kind of read like where Browning-Ferris was going to come out. And it was directed against McDonald's franchisee. And there have been now several of these issues involving McDonald's franchisees where OSHA is exploring joint employment, sua sponte, based upon this memorandum. And the IFA, in fact, has sent a Freedom of Information Act request to OSHA, which we helped prepare, asking a lot of questions. So they can have a 5-page memorandum, we can have a 6-page request for information, which we haven't gotten a response to yet, but I think it was yesterday, or maybe it was 2 days ago, Chairman Klein also sent OSHA a letter inquiring about this. And some people have opined that what OSHA is really doing is opening up a second front. So we'll see where that comes out. So the question is extremely relevant. The EEOC, they filed an amicus brief in Browning Ferris, and they said, hey, right on, brothers and sisters. We got a broader definition than any of these other definitions. You ought to follow us down the path to kumbaya. So, you know, the EEOC would say, hey, you guys haven't gone far enough, which, you know, is bad news, good news, depending upon, I guess, your point of view. But to me, the unfortunate news is you have the federal government, depending upon which agency you're dealing with a different rule. And, you know, it's what Greg was talking about. Employers, I think we're both blessed that the people that come to us for advice, they're not coming to us saying, how do I avoid the law? They're asking us, how do I comply with the law? And we say, beats me. Because there's 28 tests, and there's this, and there's that, and they keep changing it. It's an extremely frustrating experience for us. And if you have different agencies, et cetera, that, you know, coming out of the government that are doing this to you, it's a very, very frustrating position to be in as a counselor. I'm sure you know, agree. Very frustrating.
And so sort of with that in mind, Greg, what kind of costs are involved with a medium-sized or even a small corporation to have to audit all of their relationships in sort of light of all of these different factors that exist for what's an independent contractor or not, and sort of restructure or redocument? Is that become cost prohibitive for some companies, or is it even worth trying to do that since the rules are so flexible and vague?
Yeah, so there are some, like FedEx Ground, where it was simply their business model, in which case you're doing something across the board. I take it you're generally talking about the medium to large size employers where it's not their business model, but they may use a fair number of independent contractors for specific things. You can early on put many into a relatively safe bucket. Again, your plumbers, the carpenter that you brought in to do a particular construction project, and then identify what your gray area is. And what I usually find, that doesn't take a lot to do, to just kind of figure out, all right, how big is your area of risk here? And then we need to have a conversation about what it's going to actually cost to go through all of those and figure out, because again, it's not, these are the folks with respect to whom I'm not going to be able to say clearly an employee or clearly an independent contractor, and I may have to look at 4 or 5 different statutes or 5 different tests in order to tell you, well, under these 2 you're good, but under these 3 you're not. And then at the back end of that process, of course, there are tremendous costs to actually reclassifying people into employees. So that put you over the ACA line in terms of where you need to start supplying the health insurance that you're not supplying or doing it in different ways. You're paying your payroll taxes. You have to add them into your plans now. So there are a lot of costs associated with the actual reclassification, but you also may be sitting on top of a ticking time bomb depending on how many you have. And of course, one of the key considerations that most of my clients usually have as they're looking at that is it really possible for folks to get a class against us here? Because what I'm looking at is I'm worried about one guy filing an unemployment compensation claim with the state after I fire them when I treated them as an independent contractor, because that happens a lot. They file for workers' comp or they file for unemployment, and that's why the state comes into the case. If they're just worried about that one-off, in most instances, they don't want to pay a whole lot to figure that out. But if there's a chance that they've got a bunch of people similarly classified, and this is certainly true for the business model folks where independent contractors, their whole business model, but if it's not, it's actually not that easy to get a class on these issues if what you have is a few here and a few there doing very different things, because you have completely different analyses. And if you don't have a class, then a lot of folks are saying it's not worth it for me to go through the process.
One of the things you talked about in the paper that you and Missy Perry wrote for the foundation last year, Mike, was that NLRB's general counsel was using the subpoena process to sort of mine the potential targets and targets that they have out there for sort of mapping out their business relationships. Is that something that's still going on? And if it is there anything that targets of those sorts of actions can do to sort of push back against that?
Well, that's certainly what seems to be going on in McDonald's case. Again, I'm just reporting these public filings from last Friday and the brief that the board filed. I think it was on Monday, and I mean, the general counsel is not only asking for a tremendous amount of additional material, and he classified about 8 different buckets of material that are coming from a variety of different custodians, some defined by title, some actually defined by name. But he's also very critical of some of the material that's already been provided, saying that it's been redacted and there's other issues with it and there's no justification for this. I mean, I haven't seen anything quite like it. It's amazing. So, I think that the board is really going to school, certainly in the franchise context, on what McDonald's does. And they're learning a lot more about software programs and a variety of other things. And, but at the end of the day, and, this is part of the frustration, we've gone from an all the facts and circumstances test to an all the facts and circumstances test. It's just that we're providing a different legal standard, and as Greg said, in some jurisdictions it took 100 years for the state to figure out what an independent contractor was. We didn't have 100, but we had 40 or 50 years, and we could go back and say, looks like here's a case, it's pretty close to yours, and I think this is the way it would probably come out. But now we're sort of writing with a blank slate again. It's frustrating.
One final question from an online viewer for Greg. You mentioned that DOL has been giving out grants to certain states with regards to their misclassification initiative. Are there any particular states that you've seen be more active in this area that viewers need to worry about, or ones that you see sort of coming on in the next year or so that will be more active? And also, from my own question perspective, how can companies deal with state regulators vis-a-vis the federal regulators? Is there a different sort of approach that you should take, or you just sort of go to school off of what you've had to do with the federal regulators?
They are different processes. So let me first answer the question about states. So New York has had a big kick. I think that they reported they did some 28,000 audits or something like that over the last year. Illinois, Massachusetts, California. There are others, but those are ones that have reported some big totals, in particular enforcement initiatives recently. A lot of those in the states, again, come from somebody filed that unemployment compensation application, and that's what then triggers them starting to look into things. In terms of how you approach things, I mean, first of all, you have different legal standards between your federal regulator and your state regulator. The IRS, for example, right? So they're out looking to collect the taxes that are the payroll taxes that haven't been paid on these folks. They've put together, but they're also looking to just engineer people into doing it right going forward. So they have this forgiveness program that which almost nobody has signed up for, because you sign up and you get forgiveness from the IRS, but then you put a bullseye on yourself for everybody else. So even if the IRS says, all right, we won't take a look going backwards, you're not going to bind Massachusetts on that, and you're not going to bind the Labor Department, and you're not going to bind private litigants. So that's part of the problem, is in trying, you can't look at it in isolation and just think, okay, I can just solve this problem with the IRS. If you've got a public admission of some kind, it's a problem for you across the board. I do think it's state specific and it's agency specific how you have to deal with them, and there's no way I could give a concise answer as to how to do that, but tailored approaches do make sense.
I think we will end it there. Certainly we could go on for hours on this without a doubt. I want to thank you both for joining us today. Let our online viewers know two things. First, the entire program has been recorded and will be available on our website and also on our YouTube channel later this afternoon. And also, you'll see a slide there that indicates that our next program is November 5th, which is going to be focusing on the products liability concerns with the so-called Internet of Things, all these connected devices that are out there. And we've got a speaker from the Wilson Elser firm in White Plains, New York, who's going to be doing that one for us. So we should be having that information out soon. Thank you again for joining us, everyone online. Thank you, Mike and Greg, for your presentations.
Thanks for having us.
Thank you. I would appreciate it.